Hi, welcome back. This is presentation 1 of Chapter 13, the Federal Courts. One of the three big constitutional branches of the federal government. It is supposed to be the most apolitical branch. Its primary mission is to defend the Constitution. So let's jump in. Here are the key topics. Again, this is sort of the architecture of the chapter. I will not insult your intelligence by reading you the things, just give you a couple of seconds to look them over. Here are the learning objectives. Likewise, I'm not going to tell you what to think. Here's what we think you ought to get, having read and studied the material in this chapter. All right, let's jump in. Again, in the midst of the COVID-19 pandemic, you had a fight in Texas over local mask mandates. You had a young woman, Karina Pichardo, who was a Texas mom of an 11-year-old daughter. She loved going to school. At the beginning of 2021, Miranda's school district adopted a mask requirement because of the COVID-19 pandemic. Miranda, who has Down syndrome, was at a higher risk from COVID, so Karina supported the mask mandate because it enabled Miranda to attend school more safely. So again, you have a tension here. Again, this is something that happens often in politics between two relatively equally valued and important, ends, policy ends, if you will, public safety or parental rights. So unfortunately, the public health policies of local school districts became increasingly controversial in conservative states like Texas. And Texas Governor Greg Abbott issued an executive order banning local officials from requiring students or staff to wear masks. Abbott, in issuing his order, said that parents can have their children wear masks if they choose to, but there will be no government mandate requiring masks. So while Abbott posed his executive action as protecting parental rights, for the Pichardo family, it meant that they had to keep their daughter home from school because allowing it to be a matter of personal choice meant that there was a greater likelihood that there would be transmission in those public schools. So there were resulting legal challenges to Abbott's executive order, and the Pichardo family got some legal help from an advocacy group called Disability Rights Texas, and with 6 other families, they challenged Governor Abbott's executive order, arguing that it discriminated against students with disabilities. If you recall from our discussion of civil rights, they sued under the Americans with Disabilities Act. In November 2021, a federal judge ruled in the family's favor, with the judge writing, "The spread of COVID-19 poses an even greater risk for children with special health needs." The judge found that Governor Abbott's executive order violated the Americans with Disabilities Act, writing, "No student should be forced to make a choice of forfeiting their education or risking their health, and now they won't have to." Abbott vowed to appeal the decision, which would have been filed before the conservative Fifth Circuit Court of Appeals. If the cases were to continue, it could ultimately be heard in front of the Supreme Court. And I think actually it was ultimately heard, and of course the Fifth District found in support of Abbott. So in any event, again, you have this challenge here where, there are two equally valuable ends. And again, the problem was during the COVID-19 pandemic, the issue became politicized. And it wasn't, a situation where you could fairly adjudicate the question between public health and personal rights. One had to yield to another. There's not really an accommodation, and Abbott's attempt at an accommodation, frankly, exposed more people to catching COVID-19. Now, the problem, again, with COVID-19 was not that it killed everyone. It only killed about 2%. But it killed vulnerable people at much higher rates. It killed people with morbidities. And again, an obese teacher in public schools is every bit as vulnerable as a child with Down syndrome. So again, these are tough issues to try and adjudicate. So federal courts are incredibly powerful. There are 25 million cases that are tried in American courts. Those cases range from highly controversial conflicts over basic rights to mundane, property disputes. In an important sense, the role of the courts is encapsulated in a quote from Woodrow Wilson, former president, one of the only, I believe, professional political scientist who was also president. And he basically said the Supreme Court is a constitutional convention in continuous session. The meaning of Wilson's quote is that the members of the Supreme Court are uniquely positioned to interpret the Constitution. Practically speaking, the power of federal judges to interpret the scope and nature of federal laws and the rights of citizens is potentially dramatic and sweeping. And so who gets to be a judge, a federal judge, or a Supreme Court justice is enormously consequential. So the legal system generally, its basic point is to settle disputes. Courts originally referred to a place where a monarch ruled. Today, courts are comprised of venues where judges and lawyers settle disputes by an impartial trial of facts related to a dispute. The essence of rule of law is that the state and its officials are judged by the same laws as the citizenry. There are two categories of American law: criminal law, which regulates conduct and defines crimes and specifies punishment for people accused of crimes. Under criminal law, the state is always the plaintiff. In court proceedings, the plaintiff is the side bringing the legal action. In criminal law, the state acts on behalf of the victim. Civil law handles disputes among individuals, groups, and corporations, and other private entities where no real criminal activity is alleged. The major kinds of civil cases include contracts, torts, and administrative law. Contract cases involve claims of suffering resulting from the violation of terms of an agreement. An example would be Corporation A suing Distribution Company B for failing to honor a contract to deliver raw materials at a specific time, causing Corporation A to lose business. A tort involves a person charging that someone suffered injury due to another person's negligence or bad conduct. If you think about what happened in the port of Baltimore, where the ship lost power and crashed into the bridge, there are going to be people suing because, again, a number of people died as a result of that. And if there's any evidence that shipping company had not done their due diligence in keeping that ship, maintained, that would give rise to lots and lots of civil claims. Medical malpractice suits are also good examples of tort cases. Administrative law involves conflicts over jurisdiction, procedures, or authority of administrative agencies. And again, an example might involve a complaint that an agency didn't follow proper procedures when issuing new rules and regulations. Under the Administrative Procedures Act, a court would examine the agency's conduct. Precedent is really important in American jurisprudence. Courts apply statutes and abide by prior decisions, and prior decisions are called precedents. Precedents established in previous cases go to guide courts' decisions in new cases. Under the legal principle of stare decisis, which is Latin for let the decision stand, courts are obliged to apply precedent or to identify a reason why precedent does not hold or should be reversed. As part of a state's commitment to rule of law. There is this thing called a case of first impression where the argument would be that this is such a novel case that there are no existing precedents to apply. So there are types of courts. Federal and state legal systems have different levels and are shaped like a pyramid. More than 97% of all court cases are handled in state courts. Most civil and criminal cases are settled via plea bargains. Plea bargains refer to a negotiated agreement. For example, in a criminal case, a defendant would agree to plead guilty to a lesser crime in order to reverse the severity of the criminal charge or the prison sentence the defendant could potentially face. That's viewed oftentimes as a win-win. The person serves less time, and we also have to keep in mind that putting someone in jail costs the state. So it's basically an attempt by the government to say we're gonna give you less time. We're going to take less of a time in terms of an expense of taking a trial, and then we're also going to reduce our expense in terms of how long we're going to have to warehouse you. Cases originate in what are known as trial courts before a judge. Sometimes there's a jury involved. Sometimes the judge is the finder of guilt or innocence. In the event of a conviction, defendants may appeal the conviction to a higher court, which is known as a court of appeals. The federal and state courts of last resort are called Supreme Courts. And again, each state system has it. And then, of course, the federal government, you have the Supreme Court of the United States, the U.S. Supreme Court, SCOTUS, the acronym. And that is the final decider of all decisions. This is sort of a schematic that illustrates how the courts work. It doesn't really show the pyramid nature of the court, but it does show, again, here's how it works. It begins in a trial court. It moves up to the district courts. It moves up to the circuit court of appeals, and then finally to the Supreme Court. And these are the circuit courts. If you'll note, the United States, or the state of Oklahoma, is in the 10th Circuit. The 10th Circuit includes a mix of liberal and conservative states. So it's sort of a moderate circuit. The 5th and 11th and 4th districts are oftentimes viewed as fairly conservative. The 9th district, which covers an enormous amount of territory, is oftentimes considered to be among the most liberal, as is the 1st and 2nd districts. That's it for this presentation. When we come back, we will continue our discussion of the federal court systems. I'll see you next time.